Good afternoon, everyone. Happy Monday. We're excited to be here with you today. Allison Schaberg with Consolidated Planning Group. Today, let me just talk about a couple of housekeeping items I always talk about right at the beginning. We are in webinar mode today, which means that we know you're here, but we can't see you and we can't hear you, so you can have your sigh of relief now. But we do know you're here, and we want you to put your questions in the chat box, and we're going to get to as many questions as we can. We typically don't save the questions for the end. We'll take the questions throughout. I'll be monitoring the chat box for Jennifer. Today we have Jennifer Swanson here with us. She is an attorney, and she's going to be talking to us about guardianship, alternatives to guardianship, and how that relates to school-related topics and help that we might need to provide to our kids at the school. Consolidated Planning Group, we're a holistic special needs financial planning firm. We've got our information in the chat box, as does Jennifer. Today's webinar is going to be recorded, and you will get a copy of today's slides and a copy of the recording via email, either later today or tomorrow. So you don't have to take notes of every single thing because you are going to get a copy of those slides. We are a holistic special needs financial planning firm. We kind of jokingly say, you guys are the paper and we're the money, right? So from a legal perspective, a lot of times there's confusion when it comes to special needs planning and who do I need and when and do they do both? For instance, people call us all the time about special needs trust and guardianship, and that isn't what we do. We work very closely with attorneys like Jennifer on special needs trust and guardianship, but we're basically the money. How much funding do we need to have to those special needs trust? We are certified as National Social Security Advisors. We do a special analysis for benefits for your loved one, as well as maximizing benefits for you and your spouse if you're married. As it relates to Social Security, there's a lot of careful planning that goes into place for that. So we can help you with those questions like how much do I need to leave for my loved one when I'm gone? How much money needs to fund that trust? We can definitely help you with those things. But today, that is not what we're talking about. We are talking about the ever popular question about guardianship and should you or should you not. And, Jennifer, one of the things that comes across to us all the time with families is, they're kind of coming around the bend that the child might be 16, 17 and a half. And they're wondering, and they're kind of, they hear all the conversations at the school and the other groups and Facebook groups that they're in about guardianship. And the question is whether or not we should do that and what is the right door to walk through. And the truth is in Texas, they have a lot of doors that they can walk through, and you're going to talk about the different doors that they can walk through. And one thing that we tell families all the time is you don't have to know everything. When you dial that attorney to have these conversations, they're here to help you and support you and find out what the right path might be for you. So you don't have to know when you call exactly the door that you are walking through. And some people, it's crystal clear. It is definitive. There are no other options. Guardianship is what they have to do. But for so many, we see a lot of families, maybe they have a child that is high functioning autism. Maybe they have moderately low IQ, but not really an true intellectual disability. Some of our kids have maturity issues where they're really not there yet. Now, I always joke and say, are any of our kids there yet at age 18? Were we there yet? We probably weren't. But so we're going to talk about some of those things. And Jennifer, it's so nice to have you back with us. And I'm going to turn everything over to you. But guys, don't forget, put your questions in the chat box and we're going to address just as many as we can.
Thank you, Allison. It's really nice to be back. So here's my contact information. We'll have it toward the end. SPED is special education. That is my first legal love, and that's actually going to be a little bit of what we're going to talk about, how that integrates with guardianship today. So you're considering a guardianship. How do you make the best decision for your child? So I'm not going to do a huge deep dive into the intricacies of guardianship. There's lots of really good resources, in particular on the CPG YouTube website, but let's just do a quick overview. Let's talk about what happens on your kiddo, your loved one's 18th birthday. Here are the three doors. adulthood. The rights transfers. If you have a child in public school who has an IEP around age 17, you're going to get that notice of transfer of rights given to you at the ARD. And it's basically the legal requirement of the ARD to let you know, hey, mom and dad, this is what happens the day they turn 18. There's a giant transfer, and it is what it is, right? So on their 18th birthday, their rights transfer to them. In between that, if we're looking at a spectrum, you can have the rights transfer, but there's also another option in Texas called supported decision-making. I use the acronym SDM. Supported decision-making is not a guardianship. It is an agreement between you and your loved one that they will come to you for help in making those decisions. And we'll talk a little bit more about that later. And then on the most extreme end, and I say extreme not in a negative sense, but if we're talking about a spectrum, most extreme is the guardianship. And in a guardianship, it's a lawsuit. You are suing the proposed ward, the PW, for their rights as a person, maybe their rights of the estate if they have some inheritance or some property. And you're doing this because you believe that their level of capacity or their level of incapacity means that they really can't, they need a guardianship. Okay, so those are the three doors. So you're coming to their 18th birthday. How do I know which path to take? This is a question we get all the time. But let's back up. Let's go back to before the 18th birthday. Let's even go back before 17 with the notice of rights. Now, if your child is not in a public school, that's okay. The principles of what we're going to talk about today can still help you decide which door to walk through. But we're going to look at IEP. So IEP is individual education plan. And embedded within those individual education plans that you would get at your public school, this is where you're going to annual ARD meetings, you're setting those goals, there's the 3-year or sooner evaluations that school districts do. So this is a school district, a public school special education document, the IEP. Embedded within that is something we call transition services or transition plans, okay? So this is a little bit of the regulations. I'm not going to take you through it. I've highlighted the parts that I think are important. So what is a transition plan? It's a coordinated set of services, so bringing the right people together. It's results oriented. We're doing this because we want the student to achieve X, specifically to facilitate their movement from school, K through 12 or K through 18 plus, to their post-school activities. Post-school activities including post-secondary education, if that's where they're headed, vocational education, integrated employment, including supported employment. So those are some of the programs you might see through TWC, or there are some private companies that help to, do things like job coaching, things like that, adult education, adult services, independent living, or community participation. The whole spectrum of potential post-secondary options. So that's the goal of the transition plan. It's embedded in the IEP. And so before I was an attorney, I was a teacher and I taught elementary. So when parents would come to the ARD, we would say things like, oh, she's in kindergarten, we're not going to worry about transition planning now. So as an elementary school teacher, I think transition planning starts the day that they enroll in school. But typically, the ARD committee isn't going to start to address it until they're around the age of 14 or 16. And that depends on their disability, okay? So what is a transition plan? Let's continue to talk about this. I want to point out, this was as a clip that I specifically took from the TEA website. I have the link at the bottom, but I did this so that you would know that there are free resources you can look up online. They're not legal advice, I'm not vouching for them, but these are some places you can look if you have an interest in learning more about transition plans. So this specifically is coming from, this is the secondary transition guidance from TEA. And it basically outlines the same thing we just went over, right? Talks about that the transition process should begin as early as possible, elementary school teacher, but formally begins when a student turns 16. And that there's a little more to that. It can be 14 depending on the disability, but this is what it looks at. What kind of services would you get from a transition plan? Instruction is one, which is completely, that's what an IEP is for. It helps to design their instruction. related services, and we know those, some examples would be occupational therapy, physical therapy, then community experiences. This is really important. When I was a teacher, one thing we would do is we would take 2 trips a year and we would plan a recipe and then go to a local grocery store, and the kids would pick out the recipe. They would have to go through, okay, how do we find the milk, those sort of things. So it's a community experience, and that's for elementary school age, can be for any age. Development of employment or other post-adult living objectives. So you might see this in an 18 plus program where they're going out to a job, they have a job coach, someone is teaching them different skills and helping them learn how to be a good employee. And then again, daily living skills and a functional vocational evaluation. That's actually, I mentioned evaluations. Your school district can do an evaluation to look at their needs or vocational needs to help plan for the transition plan if that's needed. Okay, so that's kind of the transition plan in a nutshell. So okay, Jennifer, we're here to talk about guardianship. Why are you talking to me about transition plans? Well, let's talk about how they relate. Okay, now we're going to take a look at the Texas Estates Code, which is where you're going to find information about how to file an application for the appointment of guardianship. And that's what it's called. It's an application for guardianship. So these are the contents. These are the things that must be in the application. But if you look at the bottom, the two things I've highlighted, one of the most important things that the court wants to know is whether alternatives to guardianships, available supports and services to avoid guardianship were considered. Did you consider those alternatives? And we'll talk about what those are, okay? Would they be feasible? So this is the kind of thing that the court wants to know when you go apply for a guardianship. You have to get your PCME, that's your physician certificate, where the physician talks to your proposed ward and then fills out a form to inform the court about their level of capacity and gives a lot of medical information. That's all very important, and the court considers that. But what they really want to know is there any way to avoid a guardianship? Okay, so in the code, and we're talking about the Texas Estates Code, we have what we call least restrictive alternatives. If you're in the special education world, you're thinking least restrictive environment, LRE. This is LRA, but they're very similar. The whole idea behind both of these premises is to give children, students, young adults as much autonomy and independence as possible. So in the Texas Estates Code, we actually have an enumerated list. And this is not exhaustive, there may be other things, but an enumerated list of ways or alternatives to guardianship. And so one example would be a medical power of attorney. That might be a way to avoid a guardianship. Or a durable power of attorney. We've got declaration for mental health treatment, representative payee to manage public benefits, having a joint bank account, a management trust, a special needs trust, designating a guardian before the need arises, and then just a kind of a catch-all establishment of alternative forms of decision-making based on person-centered planning. Okay, so if any of these work, you may be able to avoid a guardianship. So let's connect the dots. Yes, ma'am.
Can we just talk a minute about the durable power of attorney and the healthcare power of attorney? Because we've actually seen some families that went this route, but then ultimately was not, the person was not deemed competent, so it wasn't accepted. Like in like a hospital setting or something like that, they were basically saying that the individual lacked capacity. So in the event of a person that has an intellectual disability. And when I speak of that, I guess I'm really speaking of an IQ of 70 or below. I mean, I guess it's up to whoever accepts it or doesn't accept it. Can you talk about that? Is there, I guess what I want you to talk about, and I know based off of the code that there's maybe never an actual for sure slam dunk, but is there a definitive path where it leans more towards a guardianship as opposed to less restrictive options? Can you just talk about that? Because we've seen Absolutely. Some people run into some real issues, and then in the last month or so, we've actually seen a family where their adult is older, like, much older, and they've never had a guardianship, and then the parents are kind of, at an age that they could be, passing away and things like that. And so then what happens to this person who can't care for themselves? So that's what I want to talk about, because we've seen some real issues with it.
No, that's a really good point, and you're right. It's always going to be on a case-by-case basis, but I think that's something that you have to consider. So these are more or less, a lot of these things, the powers of attorney are more or less contracts, right? If I give one to another person, I'm contracting with them, they're going to act on my behalf, and I'm giving them the right to do that. I have to understand what I'm giving them. And that's a really, really important thing. If your loved one can sign their name, but they don't know what they're signing, you're absolutely right. I would be worried about taking that on. And so as a professional, like in a hospital setting or as an attorney. And so that's actually one of the reasons that it's important to do a lot of pre-planning, because it might be the situation where had you had those years to start talking about it, maybe the individual would understand and could articulate, even with the below 70 IQ. We see sometimes individuals with intellectual disabilities do have some strengths and may be able to say, I want to make my own medical decisions, but I can't handle money, right? And then maybe not in that way, but they have to be able to articulate and say, no, I understand. I want my mom or my caregiver to make this decision for me. And that's not, that really does have to be on a case by case basis. And so that's why the court looks at the PCME, the certificate of medical examination, because the doctor will tell you what their capacity is, right? Can they make these decisions? Are they verbal? Do they have a mode of communication? So I think that's a fair concern. And honestly, if your loved one, if you give them something to sign and they cannot explain to you what they're signing, I would be really concerned about trying to use that document, just generally, if that's helpful.
Yeah, I think it is. We did have a question. Can we talk about the difference between a special needs trust and a joint account? I'll let you attack the special needs trust, but I do want to mention, when we have kids that are eligible for like SSI and or Medicaid, there's basically two places that you can have money above and beyond the resource limit, which is currently $2,000, and that is a special needs trust and or an ABLE account. So a lot of times SSI is going to go to that joint account or the representative payee checking account, and that's fine. We just don't want their resources, no matter what accounts they're in, totaling more than $2,000. But talk about the special needs trust just for a moment.
Yeah, absolutely. So the special needs trust, there are multiple types of trusts, and I am not an expert on every single trust, but a special needs trust is specifically for a person with a disability. It has limitations. The idea is you can leave your loved one an inheritance, you can set aside money, you can plan for their future so that they're not completely dependent on government benefits. And then the government won't touch that money so long as you follow those rules. And so the example that I give, and it may not be a great one, Allison may have a better one, but if you have a government benefit that pays your rent, your special needs trust cannot pay your rent unless you and your attorney have decided that you're okay with them losing that benefit, right? So they can't pay for the rent, but they can pay for other things, trips, education, enrichment, etc. So it has limitations. And actually there are two types of special needs trusts. There's a first party and a third party. The third party, the characterization first and third comes from where the money or the funds come from. If it's third party, it never belonged to the beneficiary. And that means that so long as you follow the rules, the government will not touch it. If it's first party, so say for instance, I'm harmed, I become disabled due to a car accident and I get a windfall of money from that. It's my money, it's come to me, it's already first party, but I can still protect myself to a degree by putting it in a first party, but it is going to be subject to the payback provision. So there's a benefit to doing the third party, which requires some pre-planning. Just one more example that I've seen is I've had people call and they'll say, my parents set up a special needs trust for my sister, they passed, The money's in her account. Can we go ahead and set that up? And the problem is they didn't set up a third-party trust. What they did is they left the special needs provision in their will, and nobody set it up before the funds transferred to the beneficiary. Now they're first-party funds. You can still protect them, but it's not the same. And you can't get to that third party once the money is recharacterized. You can't get to a third-party trust, if that makes sense.
And I just wanted to just mention that, and you hit on it, that in the event, so we always talk on a lot of our webinars, almost every webinar, we mention beneficiary designations and how important it is not to leave your special needs loved one named directly as a beneficiary on anything you have, life insurance, 401ks, 403bs, pensions, annuities, whatever. Don't name them outright. The right way to name them as a beneficiary is the supplemental needs trust for the benefit of said child, or the third party special needs trust. It could be worded either way. But to Jennifer's point, so let's say grandma and grandpa accidentally, they leave money to little Johnny because they love Johnny and they didn't know that it needed to go to a special needs trust. So they leave it to Johnny outright. So people ask me all the time, can we just not take the money? Can we just like reject the money? And the answer is no, because it's been like basically awarded to them. Can we hide the money? Can we move it around? And so basically, if that happens, what your choice is to hire an attorney, set up a first party special needs trust, and depending on how the money came in and whether or not it needs a court order, to go to the first party special needs trust. So you can get it into a special needs trust, but it is going to be a first party trust, and there is a Medicaid payback on that at the death of the individual with a disability, and there is no Medicaid payback on the third party special needs trust. So planning ahead is better.
Absolutely. And all you need is the name of the trust. And then you can let your friends and family know, little Johnny has the trust. Here's the name of it. If you want to leave something to him, please do it this way. So you don't have to fund it right away, but having it can be really powerful if it's the right thing for your kiddo. So these are the least restrictive alternatives that can potentially avoid a guardianship. Okay, so let's go ahead and connect the dots. Let's talk about how an LRA relates to my child's IEP. Okay, so one of the least restrictive alternatives and supports is the durable power of attorney. And this is specifically for financial matters. Okay, it's not healthcare, it's not education, it's just financial matters. Okay, so let's look at transition planning. So my kiddo is in high school. We're doing job coaching, we're doing travel training. That's really interesting, where you can teach them how to catch the bus depending on where you live. There's no buses where I live, but how to call an Uber, how to get to work, what to do if your bus is late or rerouted, things like that. Interviewing skills, resume drafting. So let's say you go through all of this, you have a really great transition plan, and your child is great. They love going to work, employee of the month, they're very, very good at their job, whatever it is. But when they get that paycheck, they don't know what to do with it. They know that they can cash it and they might go spend it, but they don't have a sense of, I need to pay these bills, I need to put away, I need to save, etc. Or how to use an ABLE account as another tool for planning. So holding down a job and handling money are two completely different skills, right? So if your child has a job and they're good at it, maybe and again, this all depends on their capacity and their ability to understand what they're giving you, but they give you a durable power of attorney and let you handle their finances. That's one potential way to avoid a guardianship. Okay, but you need to go back to the transition plan, and you've got to be working on those skills. Kind of like Allison alluded to, it's not inconceivable that a child or a future young adult might have the ability to understand the contract, but never have been told or instructed that this is what this means, or when I turn 18, these decisions are mine. So transition planning is a really powerful place to look and to help you plan on that guardianship or not. Okay, so let's talk about the middle door. Let's talk about supported decision making. Okay, and this is where their rights transfer. Okay, it's not a guardianship. You don't get to make decisions for them, but their asking for your help, essentially, okay? Supported decision-making is also found in the code. When I started practicing, Texas was one of, I think, 16 states that had it. So it's very progressive. I think it's a positive thing if it's completely understood and used appropriately. But supported decision-making is a process of supporting and accommodating an adult with a disability to enable the adult to make life decisions without impeding their self-determination, okay? And it is an agreement between an adult with a disability and a supporter. It's a contract. It's another agreement, okay? That they're going to need to understand in order to sign. Just because they can sign their name doesn't mean that this is appropriate for them, okay? So Texas has its own supported decision-making form. You can get it offline for free. You don't need an attorney to download it or to fill it out and to properly have it properly executed. You don't need an attorney for that. It's advisable to get advice to talk about the ins and outs because there's more to it than just this, but full disclosure, that form is available online. Now, you don't have to use that form, but it's available. This is just one section of it, okay? And this is where the person with a disability is giving their supporter the, telling them what they want help with, okay? A good transition plan, and that's not the only answer, but getting ready for this, preparing for this, talking to your child about this years in advance, knowing their strengths, knowing that they're very good at taking care of their physical health. They can go to the doctor and say, this is how I've been feeling. This is what hurts, you know, and I'll eat healthier food and feel better, those sorts of things, but they're having a really hard time managing their money. Or they're 18, but they're a junior and they just don't want to deal with their ARDs anymore. They're not ready to take over the ARD process. And they just really need you to continue to go to those ARDs with them and understand, you know, what's going on there, right? This is a list, it's not exhaustive, on the form where they go through and they say, this is what I want you to help me with. If they can't think through this list, if they're just going to check all of them, checking all of them is fine, but if you know what I'm saying, if they're not able to think through, I want mom and dad to help me find a job, but I want to buy my own clothes, I want to pick my apartment, then you really should take a look at whether this is appropriate. Because one of the things, let me back up. One of the other things parents will ask me is, well, can I just take this anywhere and use it? It's not a guardianship. It's not binding. It's revocable. It's a voluntary agreement that they can enter into, and it's an agreement that they can revoke at any time. That is also true of the powers of attorney and several other estate planning documents like living wills and things like that. They're voluntary. So if your child, your new young adult, agrees to this for a while and then 6 months out, they get a little taste of freedom and they decide they don't want your help and they revoke all of it, there's nothing you can do about it. They are adults. And that's hard for parents, and it's completely understandable why it would be, but it's really important that people understand what this is, but more importantly, what it's not. So let's go back and connect the dots, okay? So here's that excerpt of the secondary transition guide for post-school, for transition planning, okay? So we have here post-secondary education. I want my supporter to help me make decisions about getting an education or other training. Living independently. I want my supporter to help me with decisions about obtaining food, clothing, and a place to live, finding a job. So a really good transition plan can actually help make this process better because you would have already been talking about it. And let me actually add a little bit of something why I'm harping on transition plans. I think that they're one of the most, legally they're required, schools must do it, but I think they're highly overlooked in Texas. And I'm not faulting school districts, I know everybody's busy, but this is a big deal because it's not just enough to get us to our 18th birthday or to the end of our 22 plus. There's a whole life left. And the goal of an IEP is not just to get them through public school, but it's to get them ready for life, whatever that is. There's a beautiful preamble to the beginning of the IDEA. And if you're an attorney, you might think of it as poetry. Other people might just, Jennifer, it's just legalese, but The intention of the IDEA, the Individuals with Disabilities Education Act, is to give children with disabilities the same opportunity to progress as everyone else. Doesn't mean we all move at the same pace, but it helps them to get that quality of life, whatever that's going to look like. Get that as much education, whatever that's going to look like. So the transition plan is a big deal, right? It's the connection between public school and adult life. But it's genuinely often overlooked. A lot of times what I see in the ARD meetings when I go is they'll kind of say, okay, we're going to set a goal that little Johnny will research vocational schools. No one checks on the goal. No one comes back and finds out if he did it. And I'm not sure that's a meaningful goal, because researching what vocational schools are available, that's a Google search. The real question is, what skills does he have? What is he interested in? Is he interested in being a mechanic? What deficits does he have? What would keep him from being able to achieve that? Well, he doesn't have social skills, or he's lacking social skills. He doesn't take criticism really well right now. All those sorts of things. Those things can be worked through potentially, right? We can interview skills, we can talk about social skills, we can explain how to take criticism from a boss, how to follow a routine, things like that. But you have to have time to do that. It doesn't just magically happen at 18. And so that's why I actually really love the interplay between a transition plan and supported decision-making, guardianship, et cetera, because they're often seen separate, but they really do, one really does inform the other. Okay, so I think we had a couple of questions. I go really fast on this one. I'm super passionate about it. I'd love to answer more questions. It's a different take on guardianship from a pre-planning perspective, but if you spend time with CPG, you're a planner. So I'd love to answer those questions, or I can cover another topic if there's something I missed.
I want to hit on something because I want to spend more time talking about partial guardianship. So let's talk about the rights that guardianship takes away: the right to vote, the right to marry, the right to drive. A full guardianship takes those rights away. We talked about the supported decision-making agreement, and we talked about the power of attorney and the healthcare power of attorney, which, by the way, I always like to mention that I think that power of attorney and the healthcare power of attorney is an important document for your neurotypical kids that are going off to college. I'm a huge fan of that. And I am also a huge fan of having intentional conversations with your parents or any aging family members that you may have in your life about their documents, and if they have them in place, and if they've been updated, if they've appointed the right person for the healthcare power of attorney, the person that really does have the capacity to make decisions when things are tough. So anyway, I just want to mention that. But can we just talk a little bit more about this partial guardianship a little bit more? Because it seems like a lot of families might fit into that box. They don't quite fit into the box of the power of attorney and healthcare power of attorney, but they definitely don't want to go into the box of guardianship if they can avoid it. So let's talk about that.
Absolutely. So you're absolutely right. So there are an enumerated list of rights that you lose when a guardianship is granted. So let's just talk about the guardianship of the person. This is not exhaustive, but you lose the right to marry, to choose your living space, to choose where you live, to vote, to carry a gun, to drive, and then to make your own, in many cases, make your own medical decisions, make your own financial decisions. It's more, I don't want to say it's like being like a child, because that's not fair, but it's more or less someone basically telling you what you're going to do. So if a guardianship is not avoidable, exploring these alternatives, like Allison said, can still be helpful, because we've had, I've seen people who, a lot of things they couldn't do, but they followed politics. They took their civic duty very, very seriously. And so it was clear that they had at least the capacity to be able to make decisions as a voter. And so you can carve, and that's one very small example, but you can carve that out if you can present the right information to the court and say, look, they've never missed an election, and so, but you have to have that evidence. You have to have explored those alternatives. How do you know that they keep up with politics and are voting from a place of understanding, right? The same with driving, right? And that one might be a little bit confusing, but you don't really know why a person has incapacity, right? If we're talking about an intellectual disability, then we're talking about a cognitive issue. Maybe they don't have the ability to, there's a cognitive issue, let's say that. But if you're someone older, maybe it's someone who has a degenerative disease, which actually is where the guardianship in advance of need comes. You need to know these ins and outs so that you can present to the court, because that's one of the things that they're going to ask you. You can't just walk in and say, here's an IQ, this kiddo this young adult needs a guardianship. That's not enough. And the physician's certificate of medical examination is not enough, because no one individual is the same as the next. So you could have a 75 IQ with a myriad of issues and need a guardianship, or you could have a 65 and just have a tremendous amount of skill and only need a partial, or be able to use a supported decision-making agreement. So that the partials.
We've also seen high functioning autism, gifted, twice exceptional, all kinds of stuff going with super ridiculously high IQs too, that where the guardianship or partial guardianship may have been necessary. And then there's also a factor, and this has been, I don't know, I think it's been more prevalent. It was probably always there before, but the mental health issues that are debilitating, with anxiety, depression, there's so many, I call it alphabet soup of all of the initials that they throw on the mental health diagnosis, but we've seen that as well. But one thing I think it's important to talk about is that with the power of attorney and the healthcare power of attorney. So it's reasonable and not uncommon for a family to say, okay, well, we're going to try this first, the least restrictive option. We're going to try this. The kid does, have capacity, and with understanding and sitting with the attorney, they understand what they're signing, all these kinds of things, which is fine. But if you have a child, and I joke about this because, aren't all teenagers adversarial a little bit anyway? But if you have a child that is oppositional, adversarial, angry, they can revoke that. Not that they always understand that at 18, but they reserve the right to revoke that power of attorney and healthcare power of attorney at any moment. As soon as they're angry at you, they can revoke that. So that is something to keep in mind. But let's not talk about the bad thing, but let's talk about what if I have a kid and partial guardianship seems to make the most sense right now. Maybe I need to help them with medical decisions, maybe their education, maybe about where they live, but I don't want to take all of their rights away. But because I'm still hopeful and optimistic that they're going to get there. They're not there yet, but I'm still hopeful and optimistic. So if I go down this highway of this partial guardianship and my child arrives and they don't need this anymore, then we can go through the process of having the child's rights fully restored. How does that work?
You can't, it's not an easy process, which to your point is why it's completely okay to try alternatives first, if it's safe and it's feasible. But it's a similar process. You apply to the court, you go before the court, you have to provide evidence that shows what has changed. And it can be a more cumbersome process, I think, than actually getting the application for guardianship. It's done though. It can be done, but it's not as straightforward in a lot of cases as getting the application. So I think that one thing actually I think would be helpful for parents to kind of look at is the supported decision-making agreement is fine on its own. It's not usually going to be enough. If you have a child, let's say you have a child who understands, they want your help. We're not talking about, someone who's going to storm off in 6 months. The supported decision-making agreement is probably not enough. You probably need a couple other things, and you'd want to consult with an attorney, but the powers of attorney are an example, the living wills, but also education, document releases, HIPAA releases, FERPA releases for educational and medical documents so that you can be informed to help them make those decisions. Having the trust, you can take this pretty far. And, I've said this several times, but that's one of the reasons that I think it makes sense to start having this conversation with them earlier, through the transition plan, to say, here's what happens when you turn 18. Because some kiddos, I agree with Allison, when I was 18, I was ready to go to college, but I didn't want to fill out FAFSA. I didn't want to do all that on my own. And I relied heavily on my parents without a supportive decision-making agreement. They helped me until I got my first job. And I relied on them. And I think a lot of kiddos will do that naturally, or young adults do that naturally. But when we're dealing with disability, this should just be a blanket conversation we have with all of our 18-year-olds. But when we're dealing with disability, it's important to have these conversations, because even if they're not going to be adversarial to you, you don't know who in the world is going to see an opportunity with them. We've had, I've heard stories of people giving the title of their car because somebody at work needed a car, and it was a really sweet gesture, but they gave away their car, right? So you want to have those conversations ahead of time. And I think in most cases, using the transition plan, saying, hey, you're employee of the month, but you have trouble with managing money, or I know the doctor scares you, so what if you and I talk first and then you can make the decision? I think most young adults would be open to that, especially when they see it from the perspective of mom and dad are giving me space to make decisions, but they're not dropping me off at the curb. But anyway, I'm sorry, that's not exactly what you were talking about from the beginning of partial.
Let's talk about the physicians in your army, okay? Because as parents, we have armies. Maybe we have the neurologist, maybe it's a cardiologist, maybe it's a psychiatrist or a psychologist. You got your PCP. I mean, a lot of our families have multiple physicians, so you need to know who's in your army and who, if the guardianship or the partial guardianship is the right route, who's going to sign those documents? Because Jennifer, over the last 2 years, what we have seen is a heightened amount of physicians refusing to sign these documents, even though they have been, working with said, child for years. It's not like, so it's reasonable for a physician not to sign off on something if they don't know the patient, right? But I think we're seeing this more and more in these examples of high functioning cases where they're on the line, and they're on the line, but below the line clearly from an IQ score and intellectual disability, those types of things. So do you have any advice for that? Or, and I do know that licensed clinical counselors, they don't count. It has to be an MD doctor that signs off on this. It's not a nurse practitioner. Tell us a little bit more about that.
Yeah, yes, it does have to be a medical doctor, and it needs to be someone who knows the proposed ward. I haven't encountered a doctor not being willing to sign it, but with the world being on fire in the last few years, I can understand that would be happening. I guess my thought process would be the physician is supposed to be honest. So if the physician feels like this individual has a little bit of capacity, they need to reveal that to the court. And maybe that's why they're concerned, because it's a court document. But the idea is not, the physician is not making a determination about incapacity. That's the job of the court. The physician is giving their medical opinion about their current capacity, whether they're likely to make a recovery, and then goes through some more of the medical information. But like I said, the court relies on that, but they don't rely solely on that. You have to bring in other testimony. So I guess if I had a client with that situation, I would have this conversation and say, I would go back to your doctor and I would just, talk to them about this and say, look, if you don't think that this individual lacks capacity, please put it on the paper. Please tell the court honestly, because at the end of the day, the court makes the decision, not the physician. But like I said, that's probably where I would start. And then if that didn't work, I would suggest trying to find another MD who knows your kiddo pretty well. So the PCMEs are only good for 120 days in most cases. So the court wants to know that the doctor has seen them recently. But that's an interesting problem. I'm interested.
I almost envision like CE classes for doctors held by their malpractice insurance companies, like telling them not to sign this or something. I'm joking. Of course I'm joking, but we've seen enough of it that I started wondering about that. Like, where is this coming from? So 2 more things, and then we can go to the kind of what should be on your planning radar. But I want you to talk about, what about the case of a divorce? Is there a such thing as a co-guardianship? So in the case of divorce, and what if there is this case of divorce and one parent is adamantly against the guardianship? I want you to talk about that. And then the last thing I want you to talk about is, what if, because people get served in this example of the notice of filing and all this other stuff. The other parent is going to get served. Other people are going to get served. But what if that other co-parent, nobody knows where they are? Or what if that other parent is out of the country? We've seen that be an issue in Texas. So how do we address those things? And if in case people need to know how this works.
So more categories, right? You can have an uncontested guardianship or a contested guardianship. Most of the uncontested guardianships I handle are parents who are just naturally becoming the guardianship of their child who's aging into adulthood. If it's contested, then that individual has to come before the court and tell them why they're contesting it. Either I don't think this individual needs one, or I don't think so-and-so's fit, or fill in the blank. But you're right. So the code requires us to put everyone, the appropriate people, on notice. So the appropriate people are obviously going to be mom and dad, unless they're the applicants, and of course they know, and then adult siblings. So I had a situation where there is a living parent that no one has seen in like 18 years. They don't know where they are. And so in that situation, we can't notice them. We tried to find them, can't notice them. So the court allowed us to do notice by publication, which is basically putting it in the newspaper. And that was sufficient for notice. But it's some of those nuance, obviously the code is what we follow, but some courts require more than others, right? In that situation, then publishing in the newspaper was sufficient to put the parent on notice that the guardianship was moving forward. So it depends on the circumstance. We all have at least two parents biologically, but if one parent never claimed a child and that we don't know who they are, then there's different types of ways to notice, to put notice, but sometimes that's going to depend on the court. Like I said, some of them want even more notice, and some of them are fine with whatever the code requires. Did that answer your question?
So let's say there's a happy divorce and people get along good enough for the betterment of the kids. Could they be co-guardians in the example of said child?
I don't think it's out of the question. I think it's on a case-by-case basis. But I think I haven't had a situation like that. I've looked into it and researched it. I don't think it's impossible. I think you have to convince the court that you're going to be able to be co-guardians, because by nature of being divorced, you are adversarial to one another.
Right, sure. And so in the event of guardianship of a married couple, can husband and wife both be like co-guardians of their loved one?
Mm-hmm. Absolutely.
And then as far as naming, so in the example that there's one guardian, naming a successor guardian clearly is a thing that in the event of your incapacity, that another guardian steps in. I want you to talk about what happens. So in the event that the person truly should have had guardianship and there's not a guardianship in place, and they're an adult, clearly, because they're over 18 years old, guardianship should have been in place. It's not in place. Power of attorney dies with the person, right? Like, so if the power of attorney's gone, if mom and dad dies or something along those lines, what happens to this individual? So this individual, let's just say that their IQ is below 70. They lack capacity to understand what they're signing. There's no guardianship in place. And their world, as they know it, is upside down. Parents are no longer living. They're like living in this house of mom and dad's. So what happens in that? Do they become a ward of the state?
Not necessarily automatically. The sad answer is it kind of just depends on how the wind blows in that situation. Is there a sibling who's going to step in and take over and help? Are the siblings going to exploit the will and take everything and drop them off? You know what I mean? Like it's actually a really scary place to be. That's not to say that person, if that person needs a guardianship, Yeah, if they have, like, social services at some point will likely step in, right? If they know that they're there, right? We've all heard those stories about people that have disabilities or elderly people. No one knows that they're in the house and they're being exploited. Like, these are the horror stories of non-planning. But initially, it just depends on how the wind blows. If some well-meaning adult comes in, gets a guardianship, takes care of them, but they're an adult with all of their rights, the expectation is that they can take care of themselves, even though we in this scenario know that they cannot, if that makes sense. So
yeah, I mean, and my preference is obviously to plan about this and kind of think about these and have these intentional, conversations and thought processes, so that way it isn't left to chance or the way the wind blows, or if somebody steps up or doesn't step up, or things like that. So that way your choice and best interest of your loved one it's met. Like, so I think that is the key. One of the things that comes up on a pretty regular basis is, if I'm planning financially, and I need to go down a guardianship or partial guardianship highway, give us a range. We're not asking for your prices, Jennifer, but give us a range on a non-contested guardianship, full guardianship, non-contested partial guardianship. What does that look like cost-wise, approximately?
Yeah, so I think most attorneys these days for uncontested are doing a flat fee. I don't know that for sure, but so you're looking at $2,500 to $5,000 for a more experienced attorney, and that's just the cost of paying the law firm to do the work. On top of that, there are additional court costs that are out of the control of the law firm. They can't pay for you, like the filing fee, paying the attorney ad litem, who's the attorney who represents the proposed ward. Unless you're indigent, you have to pay their attorney too, and that's between $450 to $800, depending on the complexity. If it's contested, it's going to be much higher than that. And then you usually have to post bond if you're made a guardian, and that can be anywhere from $25. Generally, on the lower end, if you're just looking at the guardianship of the person, there's no estate, to depends on it can go, the bond can go way higher than that if this person like has a large inheritance that you're managing. So I would say plan like conservatively 3,000, liberally 5 to 6 for an uncontested.
Thank you for that. That question comes up all the time. And for anybody that's joining us today from Galveston County, there is a grant out there for free guardianship, and it's not like it's like an endowment or whatever that the courts have. If you have to live in Galveston County, you can't just go to Galveston County and get your guardianship for free. But if you do happen to live there, just know you can call the courts there and learn about their program. It is on their website as well. There's one other county in the state. It's not anywhere around the greater Houston area. I don't remember which one it is that has a program that I've heard of for families that are indigent. There are legal aid programs out there. There are Disability Rights Texas. I understand that the waiting list for those is quite long. I don't really have any other information on that. I know that there is a guardianship program in Fort Bend. It's not free, but I think that they do have discounted services for low income. But we do, we partner, and we're happy to make a referral wherever you might find yourself in the state. We have partners all across the state that do this kind of work. Jennifer is certainly, well-versed in these topics. And also I just wanted to, and she mentioned and kind of hit on this a little bit, but she's very, very well-versed in the art and the IEPs and the 504s and problems in the school, if you have those, or if you're needing help. So, she, may be a good resource for you for that, because that comes up from time to time on some of the challenges that folks are finding in their school or trying to get to some of those resources. But I think that the key, and I know you've mentioned it several times, and that's really what we mentioned too, is the key is to just planning. It's having those intentional conversations, talking through, learning about what it is that you don't know, and being able to make the informed decision. And, I'm kind of an advocate by nature. So, a special needs parent myself, and I found the whole transitioning process maddening at best. That's nice. That's putting it nice. I'm being very pleasant. But it was really, really hard. And that's why, our YouTube channel was born. That's why we do these webinars, to put those tools and resources in your hands so you can make informed decisions, so you can feel like you're winning. Because I know a lot of times as parents, we don't feel like we're winning because the process is so hard and you feel so behind. I'm telling you, you could feel like you're on the top of the world and just one call to the Social Security Administration, 45 minutes later, you're disconnected, and you call back and you hold for 45 more minutes. It just kind of takes the wind out of your sails. But if you'll just advance the slide to our kind of the things that should be on the special needs planning radar. Guys, we have webinars on all of these topics. They live on our YouTube channel, and you can subscribe to the YouTube channel for free. For families that are thinking of transitioning, I do want to mention that on the 26th, I guess that's this week. It's a couple more days. See, my days go together, right? On the 26th, we have a part 2 of a, residential options, basically post high school. And it's kind of, we did this one a few months ago and had a whole different, speakers on this, but it's kind of like a speed dating on post high school options, transition, residential, who we serve, how many, beds do we have, where are we located, how much do we cost, that kind of thing. So I think we have like 12 or 13 different places. And I don't know, but for a lot of parents, it's just overwhelming. There's so many places all over Texas and trying to research them. But basically in the course of an hour, you're going to find you'll be able to have a list narrowed down of the ones that you'd like to go deeper, maybe go take a tour, learn more about their programs and things like that. So I just wanted to mention that to you guys. And you can advance the slide. We work on a collaborative team at Consolidated Planning Group. We're here to help you. We are nationally certified as special needs planners, nationally certified as the Social Security advisors. And we can help with your planning needs, those future care cost estimates, the Social Security analysis. How does this all fit together? When we have family, we're going to spend 25 to 35 years in retirement. It is a long time. But when we have a loved one that has care needs for the rest of their life or a good portion of the rest of their life, it's like another retirement bucket. So planning carefully, the sooner you start, the better. You don't have to be, a gazillionaire, but starting and kind of having a plan and working your plan. Where am I? What steps have I already taken? What are the future steps that I need to take? We can help you align those steps in the order that you need to take them. So feel free to reach out. I think on our last slide, and you'll have this in your slides that you get the email on, we always offer a free consultation where you can talk to us more about your specific questions or concerns. Anytime we're doing a webinar on this, you're here for a reason, and you may not want to share those reasons kind of in the chat box for all the world to see, but you can certainly schedule a free consultation with us. We'll be happy to talk a little bit further, learn more about you and the planning that you've done so far, the questions and concerns that you have, and we'll share a little bit more about the doors that you can walk through with us. Jennifer, go back a couple of slides to your contact information. I do know that it is in the chat box. So guys, feel free to reach out to Jennifer for all of your planning needs. And one last thing I have to say, you guys have heard me say this before, if you're joining us again, legal documents are not a DIY project. Our situation when we have special needs kids is specialized, just like you're not going to take your kid that has specialized care needs to a podiatrist when they need to see a neurologist. You're not even going to take them to the PCP when they need to see the neurologist. Your situation is specialized, requires a specialist. The DIY legal projects that I have seen are usually disastrous, and we end up referring to an attorney to fix it and ends up costing you. I also suggest that when you are working with an attorney, to work with one that's nuanced and special needs. Look at that. Your brother that's the real estate attorney, he doesn't do special needs. There's specific language that goes into these first party special needs trusts that makes it qualify in the eyes of the Social Security Administration as a special needs trust. So that is why I'm not a huge fan of like DIY projects when it comes to your legal documents. So I just wanted to mention that. So I'd just like to open it up to see if there's any other questions, and I think we're at a perfect time to end. Let me see. I do see one quick question. Is part 1 on the YouTube channel? Yes, the residential panel part 1 is on the YouTube channel, so you can check that out. And then, like I said, part 2 will be this week. I believe it's on the 26th. And then someone said, I didn't get the email for last week's webinar, letter of intent. Want to see if I can get it. Yes, it is actually on the YouTube channel. And if you email us today, then they can send you the link, but you can definitely find the letter of intent on the YouTube channel. So thanks everybody, as usual, for your time today. Hope everybody has a great week. And Jennifer, thank you again for joining us. We'll look forward to partnering with you again soon.
Great to see you again.
Take care. Bye now.